privacy story, concern, gripe, and fascination. No doubt, privacy and data protection matter to all of us. Indeed, even at the time of a COVID-19 pandemic, which sows disease, death, and economic devastation around the globe, privacy remains front and center. Nations have tried to deploy data to fight the pandemic. What about contact tracing through mobile apps? Hold on. What are the privacy implications? Employees working from home, are the platforms they are using privacy compliant and secure? Going back to work in the office, can the employer take your temperature and ask about symptoms? To be sure, we're not going to answer these questions today, but to be sure, the pandemic has pushed new issues on the fore. Ladies and gentlemen, privacy belongs to everyone. The Maurice Data Protection Act 2017 has been in place for more than 2 years now. And today we can already draw some lessons. But what have we learned? Did the Act defend itself? By complying with the Data Protection Act 2017, companies have had a chance to put their data house in order by taking a closer look at what data they are collecting, what they use it for how long they keep it and share it, and whether they really need to collect and process all those data. It has allowed businesses to reduce exposure to unnecessary risks and to develop a more trustworthy relationship with their customer and commercial partners. Ladies and gentlemen, the importance of a strong corporate governance remains a key aspect to comply with the regulations. Outside the financial services industry, where separate risk committees have become an established best practice, audit committees have also begun to take a new role. They are increasingly being asked to monitor new issues such as data privacy and digitalization, exposing them to new compliance risks. The audit committee can thus assist the board with respect to this oversight responsibility and play a vital role in overseeing the data protection performance and the overall implementation of the organization's data protection strategy. To this end, the ACF Position Paper 8 has been designed as a valuable source of information for audit committee members to ask the right questions around data protection and ensure data privacy compliance. Ladies and gentlemen, to conclude, let me say that the audit committee forum is not just plain savory. Today it is clear we have wind in our sails. We have a window of opportunity to promote the standards we have established and inspire others. We will soon proceed to our next board destination, Position Paper 9, which is associated with business continuity management. Distinguished guests, ladies and gentlemen, the ACF thank you for your attendance at this launch ceremony this morning and request you to revert with any comments that you might have or any feedback on any other position paper that you can see on the table outside this room. The ACF expresses its warmest thanks and appreciation to the KPMG Mauritius team, led by Managing Partner John Chung, for the publication of Position Paper 8, which will be shortly released in its presentable and pleasant form. ACF also acknowledges the active contribution of the MIoD team, led by the interim CEO, Dr. Linda Mamet, to bring Position Paper 8 to successful close. Thank you all for your invaluable support, including organizing today's launch event. Last but not least, position paper 8 is the outcome of contributions made by members of the Audit Committee Forum. And we take this opportunity to thank you all for their time and commitment towards producing this work, which is being put across with pleasure by me on their behalf. Thank you all for your kind attention.
It is with a very great pleasure that I'm with you today. After a very fruitful collaboration between the Audit Committee Forum, ACF, and my office on the launching of the Position Paper 8 Audit Committee Guidelines on Data Protection today. This collaboration dates back to August 2019. A training session was held with the members of the Audit Committee Forum in October 2019, where members had the opportunity to familiarize themselves with the provisions of the Data Protection Act and the obligations on controllers and processes in Mauritius. That kickstarted the collaborative journey where my office assisted the ACF in the publication of the Position Paper 8. This is a unique opportunity to assess data protection compliance in private sector, our biggest clientele, if I may put it that way. Data, let us not forget, in particular, personal data, is the fuel of an organization's operations and decision-making processes, and creating appropriate protection values and safeguards is thus critical. The DPA fosters a human-centric approach to the data economy. That's a very important concept. That is the merging of human rights principles with economic principles. It's actually the most important aspect of data protection today. Digital justice is this key. Individuals' control over their data, even in complex scenarios, is to be maintained as far as practical. Your presence today shows the importance that the publication of Position Paper 8 will have on relevant private organizations in general in disseminating the importance of data protection. Ladies and gentlemen, my office held 2 annual conferences after the Data Protection Act 2017 was proclaimed in Mauritius on the 15th of January 2018 to sensitize controllers and processors in Mauritius. I hope that you had the opportunity to attend and enjoy these annual conferences where we made our best efforts to put in the momentum that should be gathered for the dissemination of the DPA. As you are also aware, the DPA is aligned with the GDPR, the EU General Data Protection Regulations, which came into force in May 2018. And this has been a global turning point for privacy internationally. So I guess you understand the importance of compliance now with the international standards making their presence very felt every day in our lives. For sure, the DPA has revolutionized the whole data protection landscape on Mauritius with new obligations and increased accountability of controllers and processors. Some of the major obligations include notification of personal data breaches to the Data Protection Office and data subjects, designation, mandatory designation of a data protection officer within an organization, evaluation of high-risk processing operations, and the execution of data protection impact assessments, prior authorizations and consultations from our office, and record of processing operations. Just to sum up these quite huge obligations, which look complicated but are not so complicated as well. So ladies and gentlemen, from January 2018 up to now, organizations can now claim to better understand their responsibilities and continuously endeavor to improve their mode of operations by putting privacy and protection of individuals' information at the forefront of their business activities. Organizations have been assessing and reviewing their processes and also perform a greater scrutiny on the information they collect, use, and share, and to question themselves on whether they actually need all the data that they collect and process. Many companies have embarked on this transformational journey, for instance, banking, insurance, manufacturing, and the offshore sectors. There have been several breaches reported to this office, and security breaches are also on the rise, unfortunately. Companies are also implementing data protection impact assessments, DPIAs, where high-risk processing is involved. So, ladies and gentlemen, the concept of privacy by design is no longer a myth today, but a prerequisite for business continuity. Therefore, legal compliance imposed on companies by DPA regarding security and organizational measures must be seen as a push for the companies to be proactive, alert, and protect their personal information assets. Your ability to keep pace with the growing complexities in digital systems, pervaded by business models relying on tracking and powerful controllers, creating inequalities in the market, will be manifested through sustained efforts to build your reputation on the market. The new decade will see the crusade for industrial data and proliferation of interconnected devices, extending the risk surface for criminal hacking. So, ladies and gentlemen, in so doing, trust will be achieved in the business community for doing business, which is primordial for long-term sustainability. To be honest, it is not and has never been easy for us, my office, to reach where we are now. But I'm quite proud because the accomplishments of the office stands out against all difficulties that we have been encountering. Because privacy has not always been in the forefront as it is today. Privacy was an alien concept 13 years ago. My office existence was questioned as to the importance of having such an office in Mauritius, a very small country. And we consistently had to prove ourselves that we are important. And today, we don't have to do it anymore because it's something which is acquired now. So after 14, let's put it that way, 14 years of experience in the field, I can tell you with a lot of certainty that this is a concept that will maintain its, let's say, its monopoly in the coming years. Because what we are seeing right now in the, around the world with COVID, especially, let me give you a very straightforward example. COVID's, the pandemic has questioned again the importance of privacy and saying that, okay, in such a concept, we don't need human rights, we don't need privacy, we need to save people's lives. But in saving people's lives, if we actually trade off their privacy, we are actually defeating the purpose of saving people's lives. So just to say that these concepts, human rights, privacy, data protection, they all work together in one direction. They don't go in contradictory positions. And even for businesses, which is you today, it's very important for your own economic survival. So let me conclude with these few lines. A smart approach to privacy by respecting human dignity will yield long-lasting results, whereas an uncaring approach will collapse the entire business ethos of the organization. My office is here to assist to ensure that risks to your reputation are alleviated through a healthy compliance to the DPA, thus encouraging a win-win situation. And I will say that the new normal today must not give way to an erosion of rights, including privacy, although pressure on organizations to maximize efficiency may lead some to believe so. Thank you so much for your attention.
Welcome to the panel discussion. The panelists that you've already met, the Data Protection Commissioner, Mrs. Rudi Jamada, Sheila Ujida, Sheila Ujidar, Chair of the Audit Committee Forum. And as you see, we've become a totally female panel. And we have replaced the one male that dared to sit amongst us. And we now have Anissa Mangru, who is the Associate Director of KPMG and Head of Risk Consulting. And she's going to be definitely an asset to this panel. I'll just give you a bit of the ground rules. We only have 30 minutes allocated to this discussion because I know many of you need to rush off to your offices. And so I would be very grateful if you could all be concise in your questions as well as in the answers. In the first 15 minutes, the panelists will respond to questions from me, the moderator, and then we should open the floor to questions from the audience. Those of you in the audience, when you're asking a question, please identify yourselves beforehand. So we've heard a lot about data protection, and as we all know, in today's digital world, there's an explosion of the volume of data created, stored and shared every second. In fact, the big tech companies, GAFA, Google, Amazon, Facebook and Apple, are among the most valuable companies globally, and their main assets are intangible. In fact, data is now a commodity, as important or even more important than oil. These companies use our personal data for their profits. Organizations are the custodians of large amounts of data, and one of the biggest single issues which can make or break a company and its reputation is data protection. So my first question is going to be to Mrs. Madder. Your office is the regulator authority for data protection in Mauritius. In your experience, to what extent are companies in Mauritius compliant with the DPA of 2017?
Okay, thank you. This is a very important question. Actually, enforcement is our main activity, and for the last years we have been focusing a lot of efforts on enforcement. But I must be very honest in this because I know, let's say for example, we have around 40,000 controllers and processors in Mauritius, even more, but we have around 20,000 who are registered with the Data Protection Office right now. So you can see half of them are not compliant. So basically with the new law now, if you're not complying with the Data Protection Act, it means you're committing an offense under the Act. And so you can be criminally prosecuted by us. And now we do our own prosecutions. We don't rely on the police as we used to do years back with the DPA 2004. So efficiency on the scale of enforcement has improved a lot, which means that there will be not too much discussions around whether you should be prosecuted or not. We will actually go for prosecution. We are setting up a prosecution unit at the office composed of police officers, and that is a reality after COVID, let's say next year. And that unit will be responsible, just like in any commission with enforcement powers, to prosecute those who are not complying with the Data Protection Act. And if you have a look at the DPA, you will find fines ranging from 50,000 to 100,000, up to a maximum of 200,000 rupees, or imprisonment from 1 year or to a maximum of 2 years. So it's quite serious. Let's be very honest about it. I'm not going to repeat it, and we also are criticized sometimes that yes, you're not doing much for enforcement and things like that. But things are how they are. We have resources issues. We have big issues at the office. The office has been depleted, but we have to survive. Just like you, we also have to survive. But prosecution now is going to be a reality, especially now you know that I give decisions, and these decisions to prosecute, many are at the tribunal of the ICT on appeal while they are being prosecuted, and some even go to Supreme Court. And we have many cases like that. So it's a legalistic function that I'm doing. And so I will not argue too much. So non-compliance is a big risk for you people.
Thank you, Mrs. Madder. My next question is for Mrs. Mangru. In your experience of heading the risk consulting function at KPMG Mauritius, what are the biggest issues faced by most companies when it comes to the implementation of the Data Protection Act?
In terms of the issues, I've been in touch with quite a lot of clients. And I think that the first issue I would touch on is the culture transformation. The implementation of a successful data privacy policy is, the first step would be, of course, the registration, appointing the DPO, and defining the policy. But it should come with a change in the mindset. The culture change is involving everyone in the company, from the board of directors to all the employees. Even those who, at face value, you might think are not related to data privacy. If I just take an example, and each time I go to client meetings, there is this notebook where I put my name and the purpose of the meeting. Should that be considered as data privacy? So really, for me, the first step is the culture transformation. Then the second, I would say, main difficulty is all the client would be asking me, who should be driving this project? Accountability. Of course, it should be from the board of directors to the people involved in handling personal data. But who should be leading this project? Is it IT? Is it HR? Is it marketing? There's no, I would say, right or wrong answer to this. It depends on the organization. You won't be setting up the same organization in a company which has 5 employees and handles employee data and directors' data versus a company which is client-facing, large volume of transactions, and handling sensitive information. So on this one, I would suggest going for senior person, understanding the business, understanding IT, not being in conflict as well with the operation, because at some point we need to report the breach to the commissioner. So really, when you're going to be appointing this person, it needs to be an all-rounder and a person who as well communicates well, because communication is key. And then the third area, and this is, I would call the black box area, is IT. We all touched on it. IT security, some would tell me, I have an IT security policy, I should be compliant. What we need to understand is that data privacy is beyond IT. A CV in a drawer would be data privacy. So really, IT and the DPO at the company needs to work together. But handling and implementing a data privacy project is really beyond IT, and we need to consider IT more as a success factor than, I would say, an end in itself.
Thank you very much. I now have a question for Sheila, turning to the role of the audit committees. Could you please indicate how the audit committee handles the situation when a company is faced with reputational risks in cases of data breaches?
Well, in fact, one of the, to begin with, I think it's important to highlight the board responsibility first. In line with the Principle 5 of the National Code of Corporate Governance, the board is responsible is responsible for the total process of risk management. And of course, reputational risks form part of it. And as part of that mandate, you have the audit committee who is there to assist the board in fulfilling that responsibility. Therefore, if there is any data breach, of course, there would be some process that needs to be followed. We need to report to the Data Protection Office within 72 hours, in line with the Act. But at the same time, we have the oversight responsibility of the Audit Committee, who's there to ensure that these reputational risks are being handled and mitigated. And of course, we will need to ensure that we have the data protection program in place. Just like Anissa mentioned, there are some pitfalls and some realities that we need to take into account, but it would be the responsibility of the board definitely to tackle that. But we need to ensure that we have proper mitigating action in place which is aligned with the compliance requirements of the Data Protection Act.
Thank you, Sheila. I think I'll allow myself a couple more questions. One more for Mrs. Maddow. Let's say that an organisation has not started implementation yet. What should they be doing in the coming months immediately?
Wow, I pity the organization. Because there's so many things to be done. But to start with, actually, registration is most important. Because when the person registers with the office, it gets concrete idea about what expectations the office will have from this particular organization. And that already demystifies the data protection concepts. So this is the first point. And then secondly, if you have an organization which just have a director with 2 employees, now who is going to be the data protection officer? The data protection officer can be the director himself, because looking at the organization actually with 3 persons, so it's basically and logically something that he can do, unless there is a big conflict of interest that he might have with his 2 employees. So that is something that he has to really look at in his own way, within his organization. We don't impose that the person should not be a director or should not be this. He can actually be anybody in the organization, but to the extent that he understands data protection to some extent. And we also give trainings at the level of the office to all controllers and processors. We do it by batch. And those who are interested, they just have to send a mail, and we train them. We train them on all the aspects of data protection to start with, and then we can actually even do an audit. We're not stealing your functions, but we do compliance audits and we do security checks. And we have forms that need to be filled, and these forms are all available on the website. So it's practically, to say, not too complicated, because you just have to work together with us, and we will help you in the process. So as I said, it's a win-win situation. We work together, we train you, you give us the fruits. Okay, thank you.
Thank you. Another question for Mrs. Mangru, Anissa. Employees have been working from home a lot during this current COVID pandemic. What kind of security measures should an organisation have in place in terms of data protection when employees are actually working from home?
So when we are working from home, the requirements of the Data Privacy or of the Data Protection Act doesn't change as such. What changes is the emerging risk. A lot of us might have not been as prepared as we would have wished before the lockdown. So the way that maybe it has been organized has generated new risk, which we haven't thought of. I would speak about this risk and maybe give some advice on how to mitigate them. The first risk is, unfortunately, your employees, because the data is accessible to them, and breaches, unfortunately, happen because of human error. And there is no magical solution to this. The solution would be training them, awareness and training. They need to be aware, and as Mrs. Maddow said, there are specialist trainings on data privacy, and you do need to customize them as well to your environment. What would be sensitive, confidential for you might not be perceived the same way by your employees. So you need to educate them, explain to them the risk, and also the reporting in terms of breaches, because they might be working from home in front of their laptop, doing a breach, and they might be terrified of telling you as well that there has been a breach. So all of these comes with awareness and training. The second, and we've all touched on it, Sheila touched on it as well in her introduction, is the cyber risk. We all speak about cyber risk. Cyber risk, you would have 2 components to it. One of the components is the weaknesses that might be in your IT infrastructure, where people could be coming in and getting the data from there. So on this one, mitigation would be securing your IT infrastructure. The second part comes back to your employee. In the cyber risk, you have what we would be calling the phishing and the vishing, which is essentially getting to your employees by all means. We've seen WhatsApp becoming very popular now, calling people on WhatsApp. sending SMSs, sending emails, trying to get information out of people. On this one, back to training and awareness. People need to be aware that these things are happening to be able to protect themselves and protect the company as well and protect personal data. The third step would be when you're working from home, you need to access information. You can't work from home just sitting at home and on your sofas and just working. So you need to be getting your laptop, you need to be using your phone, you are actually getting information from the company. The way that people are getting this information needs to be secured. You need to have, I would say, a secured channel between yourself and home, so we call that VPN, but it needs to be secured. You need to encrypt your devices. You can protect your company, and then the employee downloads this information on his laptop, and the laptop is not encrypted. So if someone gets this laptop, they could easily read it. So you need to put all these measures in place. Then another advice would be pseudo-anonymization. That means that when your employee are using information, instead of saying Anisa Manru, date of birth, my address, and whatever personal information on me, you say number 12345. So if ever, for some reason, someone gets this data, encrypts your drives, they won't know to whom it belongs. So that's protecting as well the personal data. And one consideration as well, when we are on work from home, it's the other way around, and we touched on it as well, and I think Sheila touched on it. It's the privacy of your employees. I have one client, so Mrs. Marab, just it hasn't been done. So this client told me he wants to put a tracker on the laptops to be able to track whatever activity the teams are doing to make sure that they are being productive. I think this is not allowed. So you need to as well be mindful what is it that you can do and what is in line with the data privacy laws, and you need to respect your employees as well. So let us be secured and let us respect the employees at the same time.
Thank you very much. I heard a good joke the other day. It was, do you know of a good DP consultant? And the answer is yes. And then the person said, could I have his contact details? And the answer is no. I think that we can throw the questions to the floor now, because I think we've got our 15 minutes of panel time spent. So as I said in the introduction, please introduce yourself before asking your question, and try to keep your question concise. If you wish to address the question to one specific panel member, please do so. Otherwise, we'll decide amongst ourselves who's best equipped to reply. Thank you. Do we have a roving mic available? So, who wants to ask a question? Don't be shy.
We've got one here.
Hi, my name is Sulin Ong. The question is for Mrs. Madab. Mrs. Madab, I had the opportunity to attend one of your speeches last year, and at that time you were talking about equivalent jurisdiction of our DPA with the EU GDPR, and that we had applied for this equivalence. Have we received the approval yet? And if not, what would be the implication for us if we haven't got that yet?
Very, very nice question, if I may. Yes, it's very important to highlight this aspect, and I thank you for the question. We are actually working very, very fast on this project. Actually, you should, I think, you will congratulate me. Because we are again the first African country who has ratified the Convention 108+, which is the Council of Europe Convention, the one and only convention, legally binding instrument on data protection in the world. So we are the first African country which has done that. And the protocol, which is the convention, is going to come into force once they get the required amounts of states to ratify it. And this is a big achievement for this year for the office, because we have been rushing our ambassador to the Council of Europe during COVID, and that was not an easy situation to do.
but we won a small race, that is, being the first country in Africa to do it is a very good thing for Mauritius. So this is the level of international compliance that we are in Mauritius. It means that Mauritius has to comply with all the principles that are contained in this convention. And this is serious because we have a lot of issues which relate to GDPR, also principles in the convention which are familiar, but some are not so much like in the GDPR. So you have a whole gamut of international instruments to play with. To say now the DPA aligns with GDPR, the DPA aligns with Convention 108 Plus, and we have all these principles that we have to maintain. But now going on to your next challenging question is the adequacy status of Mauritius with the European Union GDPR instrument. And we have actually reached a level where we have started negotiations with EU, and we want to be recognized as adequate with the European standards. And this has already started. We have launched what we call a consultancy paper. Not paper, I mean, we want a consultant from the Council of Europe to come and assess the situation in Mauritius. Because of COVID, this is taking some time. But we, fortunately, next year we will have a consultant who will assess the situation of Mauritius compliance. And then probably by the end of next year, depending on EU's agenda, we will actually be militating for that adequacy status very seriously. So this is the project that I'm working on right now. And I can tell you that we are on a very, very good way to achieving adequacy. I don't see why the EU will not give us adequacy, even if we're blacklisted as a country on the financial services sector, not to comment more. But this is, I think, this is my project. I will make it happen, and I'm working on it for the next coming year. I hope that it will be reality very soon. But the fact is that since we have embarked on it, so the degree of blackness is going down.
Shades of grey.
Exactly, exactly. It's not 50, it's actually more.
Thank you for that very concise answer. Any more questions? Yes.
My question, I'm Suresh Nanda from Symphony Capital. My question again to you, Mrs. Madhav. Is there a minimum size of the number of employees for which it is applicable? And also there are a lot of these private equity companies which are focused towards investment outside very, very small number of employees. Does it become applicable?
No. Your number of employees depends on your capacity and what is your economic activity. And we don't pressurize you for having, let's say, another employee to become a data protection officer.
No, what I meant is the data protection act applicable for even a single employee company?
Yes. Of course, yes, yes, yes. I got the question wrong, I'm sorry. I was focused on the beautiful dress in front, so... No, not at all. I mean, irrespective of 0 employees, being the sole director in a company is actually DPA applies. And DPA applies even to individuals who are not companies. It applies to sociétés, it applies to partnerships, it applies to any activity that a person does with personal information, except if it's only for a family recreational activities. We don't get into that. We don't bother people in their houses. But this is how far we reach in terms of compliance. And I can tell you that we have been having many cases where neighbors are complaining about CCTV cameras. And we do inquire and we do give them solutions. It's really very fast, very, very fast.
Thank you.
A question here? At the front?
My name is Kim Gale from Reuters. My question is also for Mrs. Madhav.
No, like you were looking at her and then it was
I put it straight out. So congratulations indeed on your recent signature. We're all very excited to know that Mauritius is once again in the forefront. But I have a question coming back to something which is already enacted. Perhaps the question is, of course, far too late. But I'd like to understand from your side, why in Mauritius can a DPO be criminally charged? Whereas my understanding, and unless I misunderstand this, that the GDPR, the European situation, the DPO can only be civilly charged.
Sure.
Why have we taken such a severe action against Mauritians where in Europe the action seems to be less serious?
Yes, I love your question because we have been having these questions very, very often. Why are we so severe here in Mauritius? And why? Let me now give you what is the status in the GDPR context. If you look at the financial implications involved in the GDPR, you will find that you have very hefty fines, which is beyond any imagination, which is perhaps beyond the capacity of many local companies to actually comply with. And if you look at criminal sanctioning here, how it works in Mauritius. It was criminal sanctioning before the GDPR as well. We have maintained the criminal sanctioning system because we believe that, that would be surprising perhaps to you, we believe that if a person pays a fine of 50,000 or even 100,000 compared to a fine under the GDPR, it's basically nothing. And imprisonment is applied, as you know, in Mauritius only after you pay a fine, and then you don't comply, you come back to court again, and at some point in time you may be imprisoned. It doesn't happen at the first prosecution that you're charged with. This is how our system operates. If we had to follow the GDPR way of sanctioning, it would mean millions or billions of rupees that we have to charge the companies here. So we opted for the criminal sanctioning because it's a way of protection. Because as you know, when the GDPR will attack you is just a question which is in the clouds. It's not yet here on the ground. Whereas here with the DPA, this is the thing that you have to fear actually, is if you're not complying with the DPA, what is going to be your finality? So your finality is either you pay a 50,000 or you pay 100,000. So we had to bargain from that aspect to see whether we go for the GDPR total, absolute compliance structure, or we continue the criminal sanctioning system here, which is a bit more flexible. So that's why we chose this particular component, and it makes sense in our local context. And as you know, the GDPR says, is you don't have to implement all of the provisions in the GDPR in your local context. You don't have to do that. So we decided to do it that way. Now tomorrow, let's say we are doing this adequacy procedure and they come to us, like you said, why did you maintain this and why don't you go for the GDPR compliance structure? And we have the right to say that, yes, we want to maintain, this is our national sovereignty issue, we want to maintain it that way, but we're also complying with the GDPR because our courts offer civil compensation as well, damages to people. If tomorrow someone wants to go to court and claim civil, moral and pecuniary damages, this is also possible. And this equates to administrative sanctioning under the GDPR. So at the end of the day, we are having a two-pronged sanctioning approach. That is one which is civil and one which is criminal. So it doesn't hamper the process.
Thank you. Some more questions? I think we've got about 5 minutes left, so yes, Danny.
Thank you, Danny from Untitled Chapter. One important aspect of digitization is about data. And it seems that we are struggling as a country to understand and classify data when it comes to privacy and so on. My question would be, because we've seen cases recently and for many years that certain misunderstanding at national level when it comes to data hampering the implementation of the digitization agenda. So what are we doing at your level, or perhaps your insight first, on creating that awareness about data privacy so that we don't go into two extremes? Sometimes people don't understand the data, they just leak out important information, and sometimes they don't disclose important data for the development of the country.
Thank you for this question, also very, very important question. Yes, I think just to respond in an old-fashioned way to your question, is that, you know, the regulator is always responsible for everything that happens in the area. And we assume, we don't say that we're not responsible, but it has been a very challenging task, I must say, for this office to be able to sensitize people on data protection. Why? Very simple. Is because data protection is something which is not understood at the grassroots level. It's very unfortunate, and it will never happen, that people understand you should not actually disclose your data. You should not do that. They don't understand this. As she said, it's a whole revamping of a culture transformation. And you know, when this happens is actually when, what undergoes with that is that you have a totally educated population. You have a totally digitally literate population. These are the undermining, you know, foundational principles which goes along with that education. But that's why we always, not to say always, but we target most people from the private sector, professionals, because we know that professionals are in a better position to understand what we are talking about. And to be able, like just right now, we just had this question, data protection goes to every aspect of your life, because we are talking about human rights. So basically, we're touching everybody. But I think this government, to be very clear about it, has put a lot of emphasis on data protection wherever in its agenda. You will find it manywhere. I will give you a concrete example. During the COVID situation, the Ministry of Health have been working with our office on a very constant and regular level. We have put data protection clauses in the regulations enacted during COVID. We have data protection clauses in the COVID Act, although it says that some exceptions are going to be applied. We have again put data protection clauses in the passenger, you know, passenger traveling and everything. Everywhere you go now, you will find data protection. This is a very big achievement for the country. Not to say that we are the only one militating for this. Many people are working together with us. But on sensitization, we have been doing a lot of sensitization these 2-3 years. We published a lot of guides every year on all aspects of data protection. We have published recently a code of practice for the police on smart city surveillance, although they have laws which tell them you're not bound to apply the data protection principles. Still, the Mauritius Police Force and my office, we have developed a code of practice for them, and they are following principles. The question was everywhere in Parliament. So, you see, there are small stepping stones that we are doing, but there's a lot to be done. Unfortunately, with how the office is right now, we are limiting our capacity to the most prioritized areas, but we will soon expand as we get the resources to other areas. But it's something which you don't have to bother about, because it's happening. It's in the pipeline. But sensitization, if you ask me, Madame, you know, would you mind taking a mic or a loudspeaker and go on the streets? I would never do that. Because the law is here, You apply it or not, it's your responsibility. It's not even mine. So prosecuting you is my responsibility. But whether you come and tell me, Madam, I didn't know about the law, I didn't know what, I said, I'm sorry, what can I do? You have to educate yourself. We are here to help, but we are not here to make your functions happening for you. So we do it in a way like we are partners, but we are not the sole one responsible. Thank you for that question.
As a supplement to that question, I'm just thinking about children and adolescents. What is being done to sensitize them about the risks when they're on social media of disclosing personal details?
Yeah, we have actually focused now, you will see in the DPA, there's a particular section on children that we have made the point to add. It's actually my own doings that you see in the DPA. I drafted the DPA, and so we have made sure to incorporate children as well in the DPA. So people who are playing around with children's data, they have to be very, very cautious, because we're not going to let things happen that way. And we have published guides for children, yes, and we actually in the school curriculum, we are actually teaching data protection, not we, the school is teaching data protection. We have created these educational tools where children are being educated on certain basic principles on data protection. The Minister of Education is doing that. So in schools, this is happening. And at the level of a university as well, we are working with them. Constantly, we work with the university. So we have a lot of things for children as well.
Okay, that's excellent. We've now come to the end of our time, but I'm sure if anybody's got a burning question, we could perhaps cope with it. Yes, the lady at the back, yes.
A concluding session.
Good morning, and thank you for this enriching session. My question is, I'm Chitra, I'm from a fintech company in Yemen, and I've always made sure that we are registered, we are up to date with the people. This August, some rules changed about the fees.
Yes.
So I made sure again that we re-registered ourselves. But we were made to understand that you have to register as a data controller, and the office is not yet ready to register data processors.
No. Now we are ready to register controllers and processors. I have the regulations with me. It's already passed this year, so the law is already in force. Now we are registering online all controllers and processors, and even manually at the office this is being done. So rest assured, this is already the case, and you have a new fee structure, which is, let me give it to you very quickly. Okay, so less than 6 employees, you have 1,000 rupees to pay. More than 6, up to 25 is 1,500, and more than 25 is 2,500. I think, yeah, you have to pay. So controllers or processors are being registered right now, and those who have registered under the old law actually will have to register under the new regulations again, unfortunately. But we have given a moratorium to people to register, so you have time to register.
Okay, but I'm talking about August. It's about 3 months away. So your
yes, I understand.
I insisted that we were a processor, but we have to register as a controller. Now we have a certificate as controller, and the auditor...
excuse me, no, what is your activity? Why did you register as controller?
We are a third-party data processor. We process for banks. We are a fintech company.
So why did you register as controller?
Because we felt that we had to have our certificate in place.
But you can, yeah, but that was August. August, the regulations were already in force.
Yeah.
1st of August. But what you should do now is, if you have already registered as controller, there is a particular thing that this will take perhaps some time, but I will explain to you very quickly, is that sometimes you have to register as controller and processor as well. Because you're a controller for your organization, right? But you're processing, your activity is as a processor for other organizations. So you have a double registration to make here. So you have to do it, because not everybody is a processor. Right? So because you're performing this activity, you have to do it. Before it was only controller applications being accepted. Now with the new law, you have controllers and processors.
So you have to have 2 licenses?
Yes, you need.
Thank you for that.
Yes, but the good thing is that you know now 3 years, every 3 years that you renew.
I
So
do.
you're not going to lose too much of money, don't worry.
So on that positive note, I think we better call it a day. Thank you everybody, thank you for your attendance, thank you very much.